Welcome to Courtwire, your daily dose of real courtroom drama, shocking verdicts, and justice. Hit subscribe.
What is an in knock?
Nigger knocking.
Yeah, what is that?
Going and knocking on the door and running.
But why is it nigger knocking?
That's what.
Why isn't it Caucasian knocking? Why isn't it Caucasian knocking? Why isn't Asian knocking? Why isn't some other knocking? Why is it called that?
No, that's just the way they say it.
No, that's the way you say it because that's what you said.
That's what they say. I just. That's basically. I mean, all right. I don't know what else to tell you.
No, I'm just trying to figure out why.
It's
Why would
not
you
like
call
a
it
race.
that?
It wasn't to be racist. The kids just kept knocking and knocking on my door, constantly doing that to.
Wait, hold up, did you catch that? The defendant just went from a neighborhood nuisance complaint straight into a Class A misdemeanor for assault. That escalated faster than a door slam. Now, here's where things get legally interesting.
The state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor. Range of punishment is anywhere from up to a $4,000 fine and up to 1 year in the Bexar County Jail. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea.
So what the judge is saying here is courtroom gold. Just because you agree to a plea deal does not mean the judge has to accept it. Think of it like ordering a pizza and the chef deciding last minute you are getting salad instead. If the court does not honor the plea, the defendant can back out. No harm, no foul. But there's a catch coming in.
Plea. Did you understand? Oh, you didn't understand that part? Well, so let me explain to you. And then if you don't understand, let me know. I'll help you and your attorney discuss it. So you're entering into a plea bargain agreement with the state. You understand that part? Whatever agreement that you have worked out with the state, I don't have to follow that agreement. So let's hypothetically say they want you to have probation. If I were to tell you, I'm not going to give you probation, I'm sending you to jail, then you can withdraw your plea because I have not followed your plea bargain agreement. Now, the conditions for the plea bargain agreement, that's something the court gets to decide. You understand? So if for some reason I don't follow your plea bargain agreement and I try to give you more than what you've bargained for, then you get to withdraw your plea. And it can't be used against you if you decide to go to jury trial. You understand? And by that same token, if I don't follow your plea, then what can end up happening if you withdraw your plea, then the state can say, okay, we're going to have to go to jury trial. We're going to go to jury trial. And maybe they won't be going to jury trial on a Class A misdemeanor. They'll be going to trial on the injury to the elderly. Not maybe, that's what they
So here's the real pressure point. If she pulls out of the plea, the state could go back to charging her with the original, more serious offense, injury to the elderly. That's a legal nuke compared to a misdemeanor. So this isn't it, just a tightrope walk with real consequences.
have to do. You understand? All right. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into this plea bargain agreement?
Yes.
All right. Did you understand if the court were to grant your application for deferred adjudication, if for any reason you were to violate your conditions of probation, I could revoke you and sentence you up to 1 year in the Bexar County Jail. Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Diano, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
This part always hits differently. The judge is going through a checklist. Are you entering this plea under pressure? Has anyone threatened you? It's routine. Yes, but it's also the system's last safeguard against a forced confession. And the defendant says yes to everything, without blinking.
Yes.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of assault bodily injury. There's a $500 fine. The state is recommending deferred adjudication. And there's no contact with several people. And there's a Samantha with a question mark by Did you understand that to be your plea bargain agreement?
Yeah, but that lady actually has already assaulted me twice at my.
All right, so here's the thing. The only thing I'm looking at today is once I've gone over the admonishments for you and what your rights are, then what will end up happening is the state will present evidence, and then I'll make a decision on whether or not that evidence is sufficient to find you guilty. If I find that the evidence is not sufficient to find you guilty, then I'm going to find you not guilty and say that the state didn't prove its case. However, if there's something else going on between you and this other person,
That moment right there. Pure courtroom tension. The defendant tries to pivot, claiming she was assaulted twice. But the judge shuts it down quick. That's not what we are here for today. This isn't a therapy session, it's a legal proceeding. And the court is laser focused on the current charge.
for this court today, that's something else. So what I've just read to you, did you understand that to be the plea? Defense?
Yes, sir.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, there been such motions.
No.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 6 months. There be 30 hours of community service restitution, TAP evaluation, follow recommendation, sober meetings, random UAs, and anger management. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense of assault bodily injury as a class A misdemeanor, how do you plead? Guilty, not guilty, or no contest?
No.
State any evidence.
The honor defense has no judge.
All right, and state, have you spoken with the complainant?
We have.
All right, thank you, state. You may be excused. All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
And just like that's done, guilty finding deferred, sentencing begins. But remember, deferred adjudication is like legal limbo. She avoids a conviction if she follows every condition: community service, anger management, sobriety testing, the works. One wrong step and it all comes crashing down. Would you take that deal?
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right.